Hello learners, welcome to Manifested e-learning platform. This is the block release series. We are looking at May 2016 question number 7. This is a question that has 3 parts, A, B, C, where the C part has 2 sections, section 1 and 2, and I'll read the first part. A, identify 5 persons who might apply to the court for the liquidation of a company. Now, these are the persons who have the rights, who have the locus, if we may say, to petition the court for a winding up of a company. So in the first part, we are looking at persons who can petition, the winding up, persons who can petition the winding up of a company. Persons who can petition the winding up of a company. Now, one of the persons who has the jurisdiction to petition the winding up of the company is the company itself, that the company may pass a special resolution directing or special resolution requiring or requesting to be dissolved by the court. It is also possible that the directors of the company may be moving to court to petition for the winding up of the company. The other person who also has the grounds to petition would be members other than contributories, so that we can make a distinction in the next point where we are talking about contributories. A contributory is simply a member whose shares are not fully paid up. So that the reason why we are referring to them as a contributory is that they will be required to contribute towards the company's assets if the company was wound up during this time that they were still contributories. Then in members other than contributories, we are referring to fully paid members, members whose shares are fully paid for. Now, ideally, members whose shares are fully paid for will not have the right to petition the winding up of the company unless they're able to prove to the court that they have a substantial interest and that with the winding up of the company there will be some assets available for distribution so that they are beneficiaries of the distribution. Now, the other person who may be petitioning the winding up of a company is a creditor or creditors, if there are many, and a creditor will be petitioning the winding up of the company on the basis that the company has been unable to pay debts. Then we may also have the state law office, the office of the Attorney General, petitioning the winding up of a company, and this is for the reasons of non-compliance. If the company has been perpetually non-compliant with the provisions of the Companies Act, then we may have the state law office petitioning for the winding up of such company. So all these are persons who may present a winding up petition to court, seeking the court orders to direct that a company be wound up. Then we consider part B, where the question reads that describe 5 ways in which a liquidator could distribute the assets of a company in a compulsory winding up. Now, this distribution, we will look at the 5 ways, and not only just 5 ways, we will put them in a hierarchy where we are showing the order in which this distribution is going to be made. So part B, we are looking at the distribution of assets, during winding up. Which way? How do we distribute the assets of this company as the liquidator? Now, the first item that gets the priority by the law is the costs of the winding up. the costs of the winding up, is usually the first item to be paid out of all the proceeds of the winding up. And these costs includes the liquidator's remuneration. They are the first among the payments, or they are top on the list in the payments to be made. The other thing that we must pay as the liquidator will be the preferential claims against this company. Now, in the list of these preferential claims, we are referring to payments in respect of unpaid taxes by this company. We are referring to contributions, statutory contributions in respect of the employees of the company, such as to the hospital insurance fund, the social security contributions, all fall in second in the list of priority in the distribution of the company's assets. Then after we have made payments to the preferential claims, then we will be paying, we shall be making payments in respect to the secured creditors of the company. So those creditors of the company who had been assigned some security by this company in the form of any of its assets come in next. Then we have the unsecured creditors would then be paid next. These are the creditors who had not been given any security. Then finally, we shall share any surplus. That is, if we have a surplus to the members. Share any surplus to the members. So these are the ways through which the liquidator of the company may apply the proceeds of the money realized in the liquidation process. Then we have the part C of our question, which has two sections. In the first section, the question reads, outline 6 persons who are eligible to attend meetings. Now, this is in relation to company meetings. Who will be attending company meetings? Part C, Roman 1, we are talking about persons entitled to attend, company meetings, persons entitled to attend company meetings. There are a number of persons who will be attending these meetings. First in that list will be members. Members will be entitled to attend all company meetings. Now, closely connected with members will be proxies, a person who has been appointed by a member to appear at a meeting on their behalf. Joint holders of a share or joint owners of a share. Such joint holders would also be entitled to attend these company meetings. Then a director or directors will be entitled to also be present at such company meetings. Then any alternate director appointed for the purposes of representing absent directors at meetings will also be entitled to attend. And then the auditor of the company will also be a person entitled to be present at these company meetings. In fact, one of the rights of the auditor will be to receive notices and to attend such meetings of the company. The second section of C asks us to summarize the strict statutory requirements governing notices. And this is again in relation to company meetings. So notice for a company meeting. So what is to go into notices for company meetings? Now, one of the requirements is that the notice needs to be dated. The notice requires to be dated, that it has to indicate the date of the meeting. It also needs to indicate the time, and in addition to the place where that meeting is to take place. So with a date, then we know about the appropriateness of the period of the notice. We know when to meet and where the meeting is to take place. Notices must also have the agenda of the meeting, the reason why this meeting is being called. The notice must also specify the type of meeting. The notice must also specify the type of meeting that the notice convenes. And then of importance is also the authority. The authority convening. The authority convening the meeting. The authority convening the meeting. Now, this is so important that if the notice is issued by a person without the authority to call the particular type of meeting, then that notice will amount to be a defective notice. So, dear learners, that brings us to the end of our question number 7. And that is also the end of that paper on May 2016. See you in the next series.
Thank you for watching this video. Don't forget to get yourself a copy of our professionally prepared study text and revision partners. Visit our shop along Tom Boyer Street, Pioneer House, 3rd floor, opposite Fire Station.